Welcome to John Redmann, Power of Attorney, the show that aims to empower you through knowledge of the law. I'm attorney John Redmann. Recently, Louisiana voters took to the polls to vote on 14 proposed amendments to the state constitution. 6 of the 14 amendments succeeded. Today we're going to discuss the new amendments that were passed, as well as some of the rejected amendments. And we're going to discuss how the Louisiana Constitution works in a more broad sense. Our guest today is Robert Scott, President of the Public Affairs Research Council of Louisiana, or PAR. Mr. Scott helped write a comprehensive guide to the proposed amendments for voters and has 30 years' experience as a journalist and commentator on public policy. He'll be joining us shortly to explain what the new amendments mean and how they will affect ordinary people in Louisiana. So stay tuned, and we'll be right back with our guest, Robert Scott. Welcome back to the show. On November 4th, Louisiana voters passed 6 of 14 proposed amendments to the state constitution. Joining us now to talk about the new law is Robert Scott, President of the Public Affairs Research Council of Louisiana. Robert, welcome to the show.
Thanks for having me on, and thanks for taking on this difficult subject.
Well, you know what? It's going to affect a lot of people, and it's going to affect people in different ways. So we're really glad we have someone like yourself, who you and your very prestigious organization, PAR, to help explain. And before we get into the amendments that passed, what is a constitutional amendment, we thought it would be helpful to have a little chat about the amendments that did not pass, because there were some very interesting amendments proposed, and the voters spoke very loudly about some of those. So let's start with the discussion about what you think are some of the more important amendments proposed that the voters of Louisiana rejected.
Well, that is a good place to start, and there was one amendment in particular that didn't pass. It was number 11, and it would have expanded the number of state departments from 20 to 21.
So let's make government bigger.
It would have made government. It would have expanded the number of departments. And now there was a statute that would have created a Department of Elderly Affairs. It was waiting in the wings for this to pass, and a Department of Elderly Affairs would have been created. But I think voters looked on the ballot, they saw an expansion of state government, and they said no overwhelmingly. So they really booted that one out, and that may send a message toward other political issues in the state as well.
Okay.
Well, you also had the New Orleans Ninth Ward proposal that was out there. They wanted to try to get permission to do below market value transfers of these properties that the city is holding and try to get those back into commerce. That lost. It didn't go through. And then you also had the very controversial amendment that everybody was talking about, which would have eliminated Louisiana's mandatory retirement age for judges. And we right now have a mandatory retirement age of 70 for judges. If you turn 70 as a judge, you can fill out your term, but you can't run for re-election. And so what this amendment would have done is it would have eliminated that retirement age, and the voters said no. And so we still have a mandatory retirement age.
Very interesting, and very much in the papers recently, right here in the New Orleans area, Judge Marullo from Orleans Criminal District Court, he survived challenges to his running for re-election, because I believe he just hit age 75, but he was able to argue that some aspects of the 1974 Constitution and amendments to that 74 Constitution allowed him to run for re-election. And in the Court of Appeal in the Louisiana Fourth Circuit, he was successful, and he has been re-elected now to the Court of Appeals. So I guess he's going to be grandfathered in, maybe as the right
Whether or not he's a grandfather, he might have gotten grandfathered in. But I think what a lot of people thought was that, look, the mandatory retirement age is age discrimination, and also you have a lot of experience on the bench. Why get rid of it? But the voters said no. You know, in another way, it's kind of like term limits for judges, because some elected offices in the state actually have term limits. Judges do not, and so some people looked at this as a way of sort of imposing term limits on the bench.
Kind of consistent with the voting we've seen across the country. A lot of people were saying enough big government. no, term limits is a good way of saying it. When you reach a certain age, maybe you're still able to serve, but not as a judge, not when you get past 70. Very interesting observation.
Right. And I should say the Public Affairs Research Council did not take positions on these amendments when we just tried to explain them to the public, offer pro and con arguments, and we'll continue to do the same thing here. No matter how stupid they were, we didn't take a position on them.
Excellent point. And that's one of the reasons why we invited you to come on the show. This show doesn't take any sides on any issue. We try our best to inform the public, empower you to make up your own minds about what you think is the best way to go on any subject. So we're very grateful for you and your opinions. Let's move on now. A constitutional amendment. That's not like your everyday law. Why don't you help us understand what a constitutional amendment is?
Well, no. I mean, the state constitution is the fundamental law of our land. And it lays out the basic principles of government, it lays out the basic structure of government and the rights of the citizens. And it's different from statutes, which are easier to implement, and they're not really supposed to speak to the fundamental law. The statutes are supposed to implement the law and handle the details, so to speak.
How are statutes enacted versus a constitutional amendment, which we just saw the public vote in?
That's right, very important. If you want to change the state constitution, you have to go to a public vote. You have to get a majority vote statewide in a statewide referendum in order to approve that. Plus, even to get that on the ballot, you have to have 2/3 of both the House and the Senate vote in favor of a resolution to put something on the ballot. Now, we've had since 1974, when we remade the Constitution, we've had 175 amendments. Now, even with that number, it's a vast improvement to what we had before 1974, where the Constitution was literally half the size of War and Peace, the novel.
Wow.
And nobody knew what was in it. And people were just rejecting all the amendments that were being proposed. It needed to be redone. There was a constitutional convention. We created a more concise body of work in the Constitution, but we have been changing it a lot. And the biggest problem we've had is putting a lot of minutia into the Constitution, things you really could handle in statutes, but we somehow or another want to protect things in the Constitution.
So amendments that go on the books are very powerful, and you can't take them out of the Constitution just because somebody goes to the legislature and tries to take it off the books, right?
Yeah, and for certain funds, budgetary funds that are set up for particular purposes, if you put them in the Constitution, that makes them protected from the usual budgetary process that the legislature can go through or the governor can conduct in mid-year budget cuts, where they can just go in and take money out of those various types of funds and put into the budget for other reasons. But if you put it in the Constitution as opposed to just a statutory fund, you're more protected. It's harder to do that.
Now, the only thing more powerful than a state constitution law might be a U.S. constitutional law?
Well, right, of course.
Okay.
Yes.
Now, but a statute, that's something that our elected legislators go to Congress and or the Senate.
Yeah, our legislators meet at the state capitol and try to decide what laws are going to be, and they can pass a statute either by a majority or a 2/3 vote, depending on what type of thing it is. If you want a tax increase, you need a 2/3 vote. If most bills, though, can pass with a majority vote, and they have to pass with a majority both in the House and the Senate. And if there's a veto by the governor, they'd have to survive the veto override if they're going to become a law. So statutes have a very visible process in the state legislature, but the type of subject matter that they deal with is not as fundamental as what you're supposed to have in the Constitution. Unfortunately, we have probably too much detail in the Constitution.
So to sum it up, a constitutional amendment is a very powerful law. It's very hard to overturn it or to take it away once it's on the books. A statute, it can be overturned in various ways and a lot more easily.
That's right.
And now let's get into the constitutional amendments that were passed. There were 6 total, correct?
6 out of the 14.
Okay. Why don't we get into those? There are some significant changes in our laws, constitutional amendments. Why don't we start with number 1?
Yes, and the numbers 1 and numbers 2 were both healthcare related amendments, and they both passed. These are very significant because they affect healthcare institutions in the state, they affect patients and people who use the services, and they probably also affect higher education in the sense that it may make the budget a little tougher for higher education the way these are structured in the Constitution. But just taking a quick look at them, number one passed. This dealt mostly with nursing homes and for institutional care facilities for the disabled. And what it does is it takes an existing tax or assessment that the nursing homes have, and they want that tax, so they can take those dollars that they're being taxed, match them on the federal level under the Medicaid program, and the money flows back at an even greater rate than the tax that they put in. So they end up getting more money out of it in the long run, and they like this particular taxing system. The problem that they have had in recent years is there have been occasions when that money, instead of flowing back to the nursing homes and these institutional care facilities, they've actually been sent to other Medicaid purposes. And so the nursing homes and the other facilities, they said, look, let's protect this in the Constitution, and let's make sure we get our provider rates where they should be, and let's make sure that money comes back to us. These nursing homes, they take care of people who are indigent, or they really rely on these government dollars in order to have these types of services. Some people didn't like this. People in the home care industry, for example, taking care of your aging mother, father, disabled at home, they were left out of this deal. And higher education officials were concerned about it too, because in the budgetary process, this creates a revenue flow that goes back to the nursing homes and these institutional care facilities and may leave higher ed on the short end of the stick. So that, by and large, is what happened. Now, all of this is going to be implemented, and from now on, this particular fund that protects the nursing homes will be protected in the Constitution and not just in statute.
Okay, very interesting. Now we've got about a minute and 15 seconds. Tell us about Amendment number 2 that passed.
Number 2 is similar, except it creates an assessment that does not now exist, and that's for hospitals. Hospitals don't have this type of assessment or fee, even though almost every other state has a program like this.
And who pays the assessment?
Well, the hospitals pay the assessment. And again, this is a situation where the hospitals want to pay this assessment or fee or tax or whatever you want to call it. Again, they'll take that money, it'll be matched with the federal dollars, assuming the program gets approved by the federal government. That money will flow back to the hospitals. It'll help them pay for the people who come to the hospital on Medicaid or who are uninsured, people who show up to the emergency room or need urgent care and don't have other means to pay for it. This helps compensate the hospitals for that. So they want this system so they can get compensated for all these services that they're doing.
Excellent. We have to pause right there, but after the break, we'll continue our discussion about the new constitutional amendments, and we'll get to some viewer questions after this. Welcome back. We're continuing our conversation with Robert Scott about Louisiana's new constitutional amendments. Now, we said we'd get to viewer questions, and we will, but before we do that, I want to get through the constitutional amendments. We were just wrapping up the constitutional amendment number 2. Now, you wanted to just sum that up for us.
That's right. This is the Hospital Stabilization Fund. And now that the amendment has passed, there's a new stage that this moves to. The legislature next will have to take up what the formula is going to be, how this is going to work, which hospitals are going to be assessed, how they're going to count the assessment on each hospital. For example, will it be the number of beds, at each hospital? Not every hospital is going to win in this. Some specialty hospitals that don't do much urgent care aren't crazy about it. But we'll see later on when the legislature takes this up how this will work out and exactly who's going to pay for what. And they may not take it up next session. It's there in the future if the hospitals want to pursue it.
And there will be federal dollars matching the funds that are, or the tax or the fees that are paid by these hospitals. So
that's the whole idea.
And
of
the
how
idea
it's
is our
to
community benefits those who are ill, those who have emergency medical needs. They'll benefit, we hope.
Well, yeah, the big question here is, will it help stabilize funding for the hospitals? They have several funding streams streams right now that are going to be in question in the future. And I think that's what they're worried about. They're worried about some of these other programs draining out of their revenue system, and they want to put this one back in there.
Good. Well, hopefully that'll help. So let's move on. The next one is Amendment number 6 that passed.
Oh, right. Well, this one affects New Orleans. And basically, New Orleans has several millages it charges. It has a general millage. It also
these are little small incremental taxes.
Well, they add up to millions of dollars.
Sure.
And they have a special millage for fire protection and a separate millage for police protection. Each of those is capped in the state constitution. State constitution caps all the local millages for those property taxes
and that's
all over
why
the
you need
state.
a constitutional amendment in order to change what could be taxed.
If you
right?
change the Constitution, even if you're only changing it for one parish, you have to let the people of the state decide to let that happen. And in fact, that's what happened with Amendment number 6. Statewide, they approved this change, and in Orleans Parish, they also had to have a majority vote to allow this constitutional amendment to happen. And they passed it on both levels. But that doesn't make a new tax yet. If New Orleans wants to have this new tax, the council will have to come together, put out a proposition for the public to vote on. It will lay out how much the tax will go up. It can go up as much as 10 mills on each of those special millages, and they can also try to describe what exactly it will pay for.
And this is for firefighters and police?
That's right. That's right. And the people who've been in favor of this say, look, New Orleans is still recovering. We have serious crime problems,
They've
serious
got an
safety
outstanding
problems.
debt to the police.
We've got to deal with
the
this.
Firefighters too. That's significant.
That's right. But the people who have been against it have said, look, this is going to hit businesses very hard. This is not the way to do business and economic development by raising taxes.
Well, firefighters, police put their lives on the line for us every day. I'm hoping, personally speaking, my own personal opinion, it happens for them.
Well, you'll get a chance to vote on it if you live in New Orleans. So.
Okay. What's next?
Well, disabled veterans. Amendment number 7. Anytime you put disabled veterans on a constitutional amendment, it has passed. I think we've seen a pretty consistent history in this. And what this does, it basically closes a loophole in a former constitutional amendment that was passed that gives disabled veterans sort of double the homestead exemption. And in this particular case, there was a little loophole in the VA rules on the federal level, and some people were missing out, and the legislature said, no, we always intended to keep those people in, and they went in and they closed the loophole. It only affects a few hundred or maybe 1,000 or so people, so it's not a huge impact. But that passed overwhelmingly. That was the biggest positive vote of any of them.
Yeah, I'm wondering why even some local papers came out against it. What were the reasons given by the critics?
Well, when you start making a lot of exceptions for this particular tax break, what you do is you just place a greater burden on others for making up for those taxes in some way or another. And I think they're just tired of having all the exceptions and having all this in the Constitution to begin with.
All right, and the next one, number 8?
Number 8 dealt with the Artificial Reef Development Fund, and there already has been an Artificial Reef Development Fund. And this is a good example of what happens between a statutory fund and a constitutionally protected fund. It has been a statutorily protected fund, which really means it's not very protected at all. Which means that in the annual budget process, even though this money is set up for a different purpose, the legislature and the governor under some circumstances can go in and take money out of that and put it towards other budget priorities. It has been taken to the cleaners for about $46 million in the last few years. It's been a lot of money pulled off into that, and a lot of conservationists and whatnot said, look, let's stop the blood flow out of this thing. What happens is these oil companies with these offshore platforms, they can, when those platforms are ready to be retired, they can take the very expensive method of bringing them all the way in and dismantling them and so on, or they can take a less expensive method, cut them off, pull them into a reef area. If you've ever gone fishing offshore, John, you know how great those platforms are. They're just like little mini reef systems out there with lots of fish. And so they're creating these reef systems with the leftover pieces, if you will, of these platforms. And basically the companies still pay a fee into this fund in order to do that. But that money has not been protected. And so now it's in the Constitution. It is protected, and the little spigot on that has been shut off.
So this is a sort of a win-win for Louisiana fishermen, commercial and individuals, right? And for people like myself who enjoy our wonderful seafood, and people who run restaurants and tourists who come here.
And those who want more flexibility in the state budget process, they didn't like it.
Right.
So,
people might like to help themselves to that money.
That's right.
They're the losers, and
that's right.
That sounds good to me. Okay. All right, and I believe we have one more.
There was one more that passed, and you know, when there is abandoned, blighted property, which is a real problem for especially the urban areas of the state, the local governments have a responsibility, if the taxes aren't being paid on that, to try to get those properties into new hands, try to get them cleaned up, try to get them back into commerce. You know, it reduces crime. That's the whole effort behind Amendment number 10, which passed. And all it really does is it takes that so-called redemption period, that period of time where you have to wait and go through the process before you take that property away from a former owner, in many cases a deceased person, sure. You know, and get it into the right hands of somebody who can make use of the property. It shortens the redemption period from 3 years to 18 months. It was already 18 months in New Orleans, and so Amendment number 10 is just going to put the rest of the state where New Orleans has already been.
Well, I think that covers all the amendments. And at this point, because time is running short, I want to get to our viewer questions.
Right.
So, first viewer question is as follows. The amendment that would have expanded the number of executive branch departments failed with a 70%, that is 70% of the voters saying no. Why do you think that percentage was so high?
I think it was high because I think people are just inclined not to want to see government, you know, expand. Now, the Public Affairs Research Council, our group, for decades had a real concern about the proliferation of bureaucracies and departments in state government. Over time, they managed to put some constraints on those. And this would have been an example of a case where even though those services were already being provided by other agencies, a new Department of Elderly Affairs would have consolidated all of that work. But I'm not sure if on this amendment people understood that they would have been creating a new Elderly Affairs Department or not. But they definitely were against the idea of expanding state government.
Do you think this is an example of it was a good idea, but the message or the explanation of what was trying to be accomplished wasn't delivered?
There were strong arguments both in favor of a new Department of Elderly Affairs and against it. In favor of it, people said, look, let's consolidate these services in one place, and maybe we can even get better utilization of federal dollars if we do that. And then there were others that said, look, we've already gone through a streamlining process of this bureaucracy, and the services are being already provided in the appropriate agencies who really have the knowledge base and how to work with those services. So you don't really need this. So there were two strong arguments going either way. The legislature just finally said, look, let's create a Department of Elderly Affairs, but heck, they couldn't do it because the Constitution limits the number of state departments. And we were already at 20, so they didn't have room for creating it unless they passed an amendment allowing the 21st department. That didn't happen. The Department of Elderly Affairs hasn't happened. Now the legislators who want this department will probably go back and try to consolidate two other departments and leave a space open.
Okay. They don't need an amendment to consolidate departments, I hope.
No, they probably don't. Well, in some cases, it depends on which ones they consolidate.
Ones they want.
So.
Okay. All right. Next question. Because voters rejected an amendment that would allow the state to use private collection agencies to collect outstanding tax debt, we'll continue to see the existing system. What is that system and how does it work? That's
an absolutely great question, because one of the amendments that they proposed here would have allowed local governments to use a third party, a private firm, to help go through the very complicated process of taking tax delinquent properties and in many cases for people who may be gone and may be a blighted property and may be abandoned and maybe nobody really wants it. But that local government was able to hire a third firm, usually with some legal expertise, to go through that very complicated process. It takes years to get that back on the rolls. And they were titled under state statutes to charge a 10% fee. Well, they tried to start a program like that in New Orleans, and some people opposed it, took it all the way to the state Supreme Court. The state Supreme Court said, yeah, this fee system is arbitrary, it isn't going to work, we're not going to allow you to have this third-party option. Well, then all of a sudden, all these local governments all over the state that have already been using a system like this, there are more than 40 of them that are already using a private firm, they said, what now? Are we operating under a legal or constitutional system by hiring this third party? And they said, well, let's get an amendment on there to try to make sure we can protect what we're doing. Well, now this has been rejected, and so now there's a big question mark. What is the status of these programs in the state? Is someone going to come along now and challenge one of those smaller programs and see where it goes? For some of these smaller governments, you need a lot of expertise to do this, and they like to rely on these private firms in order to execute that. They don't want to hire staff, to try to do it. And the people who are against these types of programs say, hey, the tax collector is the tax collector, and not a third-party firm.
All right, well, we're just about out of time, but why don't you sum up for us what, taking in the whole constitutional amendments results, what's the big takeaway, if you want to give us a kind of a summary of the big takeaway from the whole constitutional amendments vote?
One thing I took away from it is that people seem to be fairly tuned in. I mean, the fact that they didn't reject all or almost all of them, or just approve all or almost all of them, said to me that people are paying attention. The fact that they approved 6 out of 14 didn't seem to me just an accident. I also think the way each one is labeled is very important. Like I said, just the title on there can make a big difference. Hospital Stabilization Fund. Well, that sounds like something. You want your hospitals to be stable, so that's a good title that you want on there. And disabled veterans, let's help them out. Obviously, that might get a lot of votes too. So those are the 2 big lessons that I took away from it. People seem to be paying attention. It's so important to get educated.
Excellent discussion, excellent insights. We have to end our discussion here. There are so many important points that we weren't able to get to today, but that's all the time we have. If you visit johnredmannpoa.com, you can watch this episode with Robert Scott, and you can watch all our previous episodes that we've covered. Remember, you can learn all about everything we discussed on our show website. You can watch every episode, and you can submit your questions, and we'll try to get to them on the air. A special thanks to our guest, and thank you for watching. We'll see you next time on John Redmann, Power of Attorney.